Some cases start out as seemingly impossible, but that's not always true. With enough effort, enough time, enough creativity, sometimes you can eke out a win. Just like this case where my client was charged with armed assault with intent to murder, assault and battery with a dangerous weapon causing serious bodily injuries, and assault and battery with a dangerous weapon. These three indictments were caused by the allegation that my client had been at a basketball court, client being 17 years old. A man in his 40s asked the client to leave, and according to the man, who was a former police officer, the client freaked out. The client attacked him. The man called the police. The client attacked him again. The second attack was on film. The man was on the phone with the police. The client's 21-year-old brother came, and the two brothers proceeded to beat up this guy. Some of it caught on audio, where the man was screaming as he was talking to 911, where the brother stabbed the guy. Both clients were charged with the same conduct. My client was charged under the theory of joint venture, which requires that both shared the same intent and took steps to effectuate the conduct that occurred. Certainly they both took steps. And in addition to the audio that was on the 911 recorded call, there was video. The video was gruesome. The video was there for everyone to see, including ultimately the jury in this case. Now, the clients were tried separately. My client was tried about a week ago. The brother hasn't been tried yet. And so our theory wasn't that this didn't occur, but our theory had always been that my client didn't know what the brother was likely to do, didn't know that the brother was going to have a knife. In fact, the client and the brother weren't together. The client was alone. He was waiting for his brother. And the brother came, and the two allegedly attacked this guy. Now, it came to light that this guy was a former police officer. It also came to light that this person had been terminated from the police department after a long career in disgrace. He had been terminated. We weren't allowed to use any of that at trial, but he had been terminated. So he had the second career. He worked at a gym. And according to him, the client freaked out. He testified on the stand, and his testimony was he asked the client to leave. The client got belligerent. The client physically attacked him. And then the client and his brother attacked him. Now, that never really made a lot of sense to me. And I argued to the jury that they could use their common sense. And in really looking at the evidence and piecing together the different views of the cameras, we actually discovered that there was some video outside, and it showed an initial altercation, but there was very conveniently about a minute or two that was just cut out. So you could see things, you could see the client, and then it was cut out, and you could see the client and the guy outside together. Now, the client said that he was attacked outside, that he was physically attacked, that there was a verbal altercation, and he admittedly was not very nice to the other guy in his verbal responses. They were both sort of mean to each other, but that the older gentleman, the former police officer, attacked him first. And then the client was upset. And that made more sense, because why would an older brother be so upset to stab a stranger? Because his little brother already beat up the guy? Makes much more sense that the guy had beaten up the younger brother, or had physically attacked the younger brother at least. That would have enraged an older brother. That would have enraged the client who sought retaliation. And so it didn't come to light until trial, because we did all the discovery we could, but you're not allowed to do depositions. You can only ask an investigator to go speak with witnesses, but you can't force them. So you don't know exactly what people are going to say until trial. But you gather enough information that whatever they say, you sort of know the universe of what's already there. So you know some parameters. If they say one thing, it's going to sound outlandish. But still, you can't prepare for everything that they're going to say. And in this case, the person who produced the videos was the owner or part owner of the gym. It came to light that this part owner had known the former cop for about 30 years, 30 plus years. Knew him very well. They had been personal friends. And of course now, the police officer, former cop, had worked for this friend of his who owned the gym. So you can understand that this person who owned the gym wouldn't want to get sued, right, if his employee had beat up a kid. You can understand that he might want to protect his friend, who he's known for a very long time. And you can't understand this next part. I certainly can't. The police showed up right after the scene. They arrested my client and his brother. They looked at some video, but they didn't look at the video of the actual stabbing or of the fight. They only looked at video afterwards that showed the client and his brother going outside to look for the knife so they could try to track down where the knife was allegedly thrown. But then they never looked at the actual video. And in fact, they never had another officer go to get the video, to extract the video, to oversee the extraction of the video. Instead, they delegated that to the owner of the gym. In fact, the owner of the gym testified that the police told him to just get whatever's relevant. Just gather whatever relevant video you can find about the incident and give it to us. And he did. He produced it to the police, and they relied completely on him. Unbelievable, in my opinion. In addition, he had produced the indoor video days later, but then it took him additional time to produce the outside video, which was the pertinent part. The pertinent part where it would have shown my client being attacked. The pertinent part that would have shown where those 2 minutes, 1 or 2 minutes, were just completely taken out. Just spliced from the video. So with that, it still didn't negate what was on the video inside. The video inside played completely. But it was enough where we could call into question the police investigation. They had the ability. They certainly have people who are tech savvy. They have specialized units where they could have had somebody extract rather than relying on a biased third-party, non-police witness. So, because of that, I was able to argue the police investigation was shoddy. It was faulty. I was able to argue that the person who extracted the video had motives to extract video that was helpful to his employee / good friend. But I was never able to get out the video of my client allegedly attacking the guy with his brother. In fact, my client testified and he acknowledged what he did. What our theory was to ask for not guilties on all 3 indictments, which I did, and I argued that we're relying on an incomplete police investigation, and when we're dealing with a conviction, this is such a high burden for the prosecution to prove that they must be able to have a completely thorough, unbiased police investigation on which to rest their evidence, and it simply wasn't the case here. It wasn't enough. We ended up getting a conviction on the lowest of the 3, the assault and battery with a dangerous weapon being my client's shoe. If you wear a shoe in Massachusetts and you kick somebody, they call that a shod foot, and that is enough to constitute assault and battery with a dangerous weapon. We knew that going in we were going to lose that. And in fact, if the prosecutor had offered a plea with assault and battery with a dangerous weapon, the shod foot, my client very well might have taken a plea. That would have been justice. But instead, the prosecutor was pushing for a 5 to 7 year prison sentence if the client had taken a plea. Probably would have asked for more on a conviction. On a plea, 5 to 7 years for a guy that had never been in trouble before and for a guy that didn't do the stabbing. In fact, they were offering the same plea and the same charges, pleading guilty to all 3 indictments, same as the brother who had actually allegedly done the stabbing. Not fair. It doesn't incentivize anyone to plead out. And so, of course, my client didn't want to plead out to things that he didn't do. So he testified, and I thought he came across well. He was able to say that he did hit and kick the other guy. He said it was regrettable. He said he was in a mindset where he had just been attacked, and yes, he was angry. He acknowledged all of that. He acknowledged that he told his brother, who was on the way, that he had just been attacked. But he unequivocally testified that he did not ask the brother to bring in a knife. He did not know that he was going to bring in a knife. He did not have any idea that the man was even stabbed. The attack took all of 30 seconds, and they walked away, and then the police encountered them on their way out. The guy came out shortly after, limping and holding himself, and said, "Those are the guys that stabbed me." And the client testified that his mind was blown. He had no idea that his brother would stab this guy. Until that moment, he had no idea that the stabbing had even occurred. And he came across truthful, and I believe he was truthful. And in the end, the jury acquitted him of the most serious indictments of armed assault with intent to murder and assault and battery with a dangerous weapon causing serious bodily injury. In the end, we got the right result, but only because my client had the courage to go to trial. Many people don't have the courage to go to trial, and sometimes you absolutely have to take the risk. There's always a risk. It could have gone another way, but it went the right way. And jury trials are the best thing we've got in our justice system, so that we're not just relying on prosecutors to do the right thing, and not even relying on judges to do the right thing, because sometimes you've got to pick a jury of 12 citizens who are independent, who are going to actually listen to both sides and make a fair determination.